Property Management Practice Test. Question 1. A licensee preparing for a property management audit must recognize a transaction participant who receives services but is not represented as a client. Which concept does this describe? Option A, customer. Option B, accounting duty. Option C, loyalty duty. Option D, designated agency. The correct answer is option A, customer. The person should not assume confidential advice or negotiation advocacy is being provided. Agency disclosures help distinguish this role from represented status. The licensee must act honestly and disclose material facts but does not owe undivided loyalty. Question 2. Which answer correctly classifies a situation involving directing housing consumers toward or away from areas based on protected characteristics? Option A, cloud on title. Option B, steering. Option C, radon. Option D, environmental site assessment. The correct answer is option B, steering. Licensees should provide objective property and community information based on the client's stated criteria. Comments about neighborhood composition or where a family would fit can create violations. The practice restricts consumer choice and perpetuates segregation. Question 3. At a settlement preparation in Ocean City, PREA explains the federal law establishing liability and cleanup authority for releases of hazardous substances. Which real estate principle is involved? Option A, material defect disclosure. Option B, underground storage tank. Option C, CERCLA. Option D, Megan's Law notice. The correct answer is option C, CERCLA. Potentially responsible parties can face substantial cleanup obligations. Liability can extend beyond the person who originally caused the contamination. Environmental due diligence may support statutory defenses for qualifying purchasers. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee A-Pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. A transaction file for a townhouse raises an issue involving an agreement among competitors to establish or stabilize prices or commission terms. Which answer best resolves the classification? Option A, actual notice. Option B, reasonable accommodation. Option C, title insurance. Option D, price fixing. The correct answer is option D, price fixing. The agreement can be unlawful even when the chosen rate appears reasonable. Each brokerage must make independent pricing decisions. Informal conversations or coordinated minimum fees can create serious risk. Question 5. Which concept should a property manager apply to facts involving the obligation to protect private information learned through representation? Option A, confidentiality duty. Option B, buyer's agent. Option C, dual agent. Option D, fiduciary duty. The correct answer is option A, confidentiality duty. Negotiating limits, motivation, and personal circumstances generally remain protected unless disclosure is authorized or legally required. It does not permit concealment of material property defects that law requires to be disclosed. The duty can continue after the agency relationship ends. Question 6. Imani is studying a rule concerning the broker activity that begins an uninterrupted chain of events leading to a completed transaction. Which term should be chosen? Option A, seller's agent. Option B, a procuring cause. Option C, express agency. Option D, ministerial act. The correct answer is option B, procuring cause. The listing and cooperation agreements govern the compensation analysis. Compensation disputes may turn on who caused the buyer and seller to reach agreement. Merely introducing a person to a property is not always sufficient if the chain was abandoned or broken. Question 7. When an office building transaction involves a change in a housing rule or service needed for a person with a disability to have equal use and enjoyment, which answer identifies the controlling concept? Option A, actual notice. Option B, abstract of title. Option C, reasonable accommodation. Option D, general warranty deed. The correct answer is option C, reasonable accommodation. A housing provider may request limited information when the need is not obvious. Approval is required unless the request creates an undue burden or fundamental alteration. The request concerns policy or procedure rather than a structural change. Question 8. A practice question describes a deed limiting the grantor's title covenants to defects arising during the grantor's ownership. Which response is best in the lease negotiation described? Option A, environmental site assessment. Option B, material defect disclosure. Option C, reasonable modification. Option D, special warranty deed. The correct answer is option D, special warranty deed. Title insurance may still be important because earlier defects remain possible. The instrument provides more protection than a deed with no covenants but less than a full general warranty. The grantor does not broadly warrant against problems created by earlier owners. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. During a pre-listing meeting, which principle is illustrated by knowledge the law attributes to a person because information is available in public records or through visible possession? Option A, a constructive notice. Option B, actual notice. Option C, underground storage tank. Option D, price fixing. The correct answer is option A, constructive notice. A purchaser is expected to investigate recorded documents affecting title. Open occupancy by another person may also create a duty to inquire. The person cannot avoid the legal effect merely by claiming not to have looked. Question 10. Which answer states the concept associated with a contractual right to match or accept terms when an owner decides to sell in the title examination described? Option A, a valid contract. Option B, right of first refusal. Option C, a lease. Option D, a specific performance. The correct answer is option B, right of first refusal. Once a qualifying third-party offer exists, the holder receives the opportunity defined by the agreement. The right does not usually force the owner to offer the property before deciding to market it. The wording controls notice, timing, and covered transactions. Question 11. A appraiser handling a mixed-use property in Hagerstown must identify a contract transferring possession and use for a term while the owner retains title. Which choice is correct? Option A, statute of frauds. Option B, acceptance. Option C, a lease. Option D, avoidable contract. The correct answer is option C, lease. The tenant receives of the rental agreement hold interest and owes duties stated in the agreement and law. The document does not convey fee ownership to the occupant. Rent, duration, maintenance, and permitted use are central terms. Question 12. During an inspection period for a subdivision lot in Saginaw, RENA needs to identify the rule described as an agreement containing competent parties, lawful objective, offer and acceptance, consideration, and required formalities. Which answer applies? Option A, right of first refusal. Option B, purchase agreement. Option C, time is of the essence. Option D, a valid contract. The correct answer is option D, valid contract. Some real estate agreements must also satisfy writing and signature requirements. A binding agreement requires mutual assent to definite terms and legally sufficient consideration. The parties must have capacity and the purpose cannot violate law or public policy. Question 13. A tenant is reviewing a small apartment building in Salisbury. Which term describes a naturally occurring radioactive gas that can accumulate in buildings? Option A, radon. Option B, reasonable modification. Option C, quitclaim deed. Option D, block busting. The correct answer is option A, radon. Long-term exposure can create serious health risk. Mitigation systems can reduce levels when elevated readings are found. The gas is colorless and odorless, so testing is necessary to determine concentration. Question 14. At a buyer consultation, a Michigan exam candidate encounters the following description: inducing owners to sell by suggesting protected groups are moving into the area and property values will decline. Which concept is being tested? Option A, antitrust law. Option B, block busting. Option C, radon. Option D, lead-based paint disclosure. The correct answer is option B, block busting. Marketing should never use protected class change as a reason to buy or sell. It is prohibited even if the licensee claims the statement reflects market opinion. The conduct exploits fear and discriminatory assumptions for transaction activity. Question 15. Kara is assisting with a condominium unit transaction in Lansing. Which principle applies when the facts involve a definite proposal communicated with intent to be bound upon acceptance? Option A, right of first refusal. Option B, novation. Option C, offer. Option D, the specific performance. The correct answer is option C, offer. The terms must be sufficiently clear for the recipient to understand the proposed bargain. An advertisement is usually an invitation to negotiate unless it is unusually specific and leaves nothing open. The proposal can terminate through revocation, rejection, counter-proposal, lapse, or operation of law. Question 16. Which answer most accurately identifies denying or limiting lending or related services in geographic areas associated with protected groups in a real estate transaction? Option A, asbestos. Option B, reasonable modification. Option C, Americans with Disabilities Act. Option D, redlining. The correct answer is option D, redlining. Underwriting decisions must rely on legitimate risk factors rather than neighborhood demographics. The practice concerns unequal access to credit and financial services. Mapping or coding practices can create evidence of discriminatory treatment. Question 17. A question arising during financing review concerns a non-exclusive arrangement allowing multiple brokers to seek a buyer, with compensation generally owed to the successful procuring broker. Which choice gives the best classification? Option A, open listing. Option B, a valid contract. Option C, executed contract. Option D, purchase agreement. The correct answer is option A, open listing. The owner may also retain the right to sell independently without paying a broker. Clear documentation is important because competing efforts can create compensation disputes. No single broker receives exclusive marketing authority. Question 18. While analyzing a warehouse, Daria must apply the concept involving a relationship inferred from conduct rather than clearly stated agreement. Which answer should be selected? Option A, a disclosure duty. Option B, implied agency. Option C, express agency. Option D, material fact. The correct answer is option B, implied agency. Clear disclosure and documentation reduce accidental agency claims. Repeated advice and advocacy can create expectations of representation even when no writing exists. Licensees should avoid conduct that conflicts with required written brokerage agreements. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. Which real estate term is defined by one agent or brokerage representative acting for both sides in the same transaction with required informed consent? Option A, fiduciary duty. Option B, a disclosure duty. Option C, dual agent. Option D, ministerial act. The correct answer is option C, dual agent. The agent must remain neutral on confidential matters and comply with state-specific authorization rules. Without valid consent, representing both sides can violate agency law. The arrangement creates inherent conflicts because the parties' bargaining interests may differ. Question 20. In a transaction involving a vacant parcel, which rule controls when there is an agreement in which all parties have completed their promised performance? Option A, a net listing. Option B, open listing. Option C, purchase agreement. Option D, executed contract. The correct answer is option D, executed contract. A signed purchase contract awaiting closing is usually still executory. The term describes performance status rather than the presence of signatures. No material contractual duties remain outstanding after full performance. Question 21. A buyer asks about an agreement with no legal effect from the beginning. Which answer provides the legally accurate concept? Option A, void contract. Option B, acceptance. Option C, specific performance. Option D, option contract. The correct answer is option A, void contract. No party can enforce an arrangement that lacks a fundamental legal requirement or has an illegal purpose. Later approval ordinarily cannot cure an agreement that was never legally valid. This differs from a contract that is valid unless a protected party chooses to avoid it. Question 22. Jonah encounters communication of a known condition that significantly affects value, desirability, or safety during a title examination. Which principle should guide the analysis? Option A, title insurance. Option B, material defect disclosure. Option C, recording. Option D, market allocation. The correct answer is option B, material defect disclosure. The duty can apply even when a seller prefers silence. A licensee should not conceal a serious problem or make misleading assurances. Experts should evaluate technical conditions outside the licensee's competence. Question 23. Which choice best matches the description a licensee engaged to represent a purchaser or prospective purchaser in the due diligence meeting described? Option A, general agent. Option B, agency by ratification. Option C, buyer's agent. Option D, accounting duty. The correct answer is option C, buyer's agent. The representative assists with evaluation, offer preparation, negotiation, and protection of the buyer's interests. The relationship and compensation terms should be stated in the brokerage agreement. Confidential information about the buyer's motivation or maximum price must be protected. Question 24. During review of a retail suite in Gaithersburg, the parties discuss a fibrous material formerly used in insulation, fireproofing, and building products. Which term applies? Option A, steering. Option B, environmental site assessment. Option C, antitrust law. Option D, asbestos. The correct answer is option D, asbestos. Its presence does not automatically require removal if it is intact and safely managed. The material is most hazardous when disturbed fibers become airborne. Proper inspection and removal require qualified professionals. Question 25. An exam scenario presents a brokerage arrangement assigning different affiliated licensees to represent opposing clients while the broker manages conflicts under state law. Which answer is most accurate? Option A, designated agency. Option B, ministerial act. Option C, client. Option D, reasonable care. The correct answer is option A, designated agency. The supervising broker's role and consent requirements depend on the jurisdiction. The structure is intended to provide representation within the same brokerage without one salesperson advising both sides. Each assigned representative advocates for one client and protects that client's confidential information.